wind down session. Judge Paige Reese Whitaker presiding. Court come on.
Good morning. Good morning. Okay, let's go ahead and get defense counsel. I know I've been just in chambers making some edits to the instructions. Figured it was easy enough to do that back there instead of here. Do you want to let the, are the defense attorneys back in that conference room? Well, they may not know that I'm here, so. Mr. Kendrick, did they let you sleep this morning? Okay. Good morning. Is the verdict form that you were working on latest version of the charges. I did some further edits this morning, caught some things that needed to be said differently. So she's going to send that right now, and y'all can take a look at it. And did any of y'all have edits that you noticed that need to be dealt with? No. Okay. Okay. All right. So one question I had is, we've got conspiracy, the 2.021020, and then presence of the parties right now kind of set out also as separate charges, but I don't know who requested that, but I'm kind of thinking we've already covered what those mean, and it may be that in our overt acts there's a conspiracy to commit a crime that's an actual allegation, so that I would need to charge it with the overt acts. But do we need to charge separately, or does somebody want that as a separate charge?
You said conspiracy?
Yeah.
And what were the other two?
It's conspiracy, and then there are additional instructions about conspiracy, and then there's the presence, conduct, companionship before and after an alleged offense may be considered by you in determining whether they give rise to an inference of a conspiracy.
I don't think we need any of that.
I mean, I feel like we kind of already explained, here's what conspiracy means within the RICO statute.
I think that's correct. I agree with Mr. Sharp.
Okay, state,
No objection, Your Honor.
to taking those out?
Correct.
Okay. All right. So another thing we need to do, now that we just have the 106, possession of a firearm by a convicted felon, that does have a pattern. It's really simple. It's just for possession of a firearm by a convicted felon, the state must prove the defendant possessed a firearm after having been convicted of a felony. And then there's a blank to say these particular things are felonies. So I don't know what the convictions of these two defendants are that have come in right offhand, but I would think that that's what's supposed to get listed in the blank.
I think probably whatever convictions are listed in the indictment as the predicates for the possession of firearms would be the ones that we would list there.
Well,
And
are those convictions for these defendants in? I thought that was the whole.
Yes, Your Honor. So the underlying convictions for at least Mr. Kendrick is in. Your Honor, the underlying conviction for Mr. Stillwell, that is a conviction that I was looking for right before the state rested its case. I was going through a folder. It's supposed to be Exhibit 34Q. I do not see 34Q inside of the documentation that is sitting there. That's the only exhibit missing, and so we are trying to find 34Q. I believe the court said that
I did.
we can open it up for that, that limited purpose, but that is the exhibit that we've been looking for with the 34Q, which is the 15 SC. I think the last digit ends in 6. I don't remember the entire indictment.
Have you gotten through all of the evidence?
Not since not since Monday or Tuesday when we rested, to determine if it's
Okay. So, all right, you just hadn't checked yet.
Yeah.
Okay. All right, so for Mr. Stillwell, it's the felony that he's charged with in count 52 as having already been convicted of is actually also possession of a firearm by a convicted, 2 counts of possession of a firearm by a convicted felon, a 15 and a 19 SC. Is that your understanding? Okay. Well, that's not charged in this indictment, in this count. So I guess then what we would say there is crazily circular. Possession of a firearm by a convicted felon is a felony. He's charged with two counts of that. Or no, just one. And then Mr. Kendrick's charged with. So looking at the possession of a firearm by a convicted felon charge against Mr. Kendrick, one of his alleged prior felonies is also possession of a firearm by a convicted felon, but the other one is possession of a firearm during the commission or attempt to commit certain crimes. Do y'all know what that was specifically? Like, was he specifically charged? Was it just during the commission of a felony? The way it was charged?
Yeah, he was charged in 15 SC 140116 with possession of a firearm during the commission of certain felonies, which would have been participation in criminal street gang activity, conspiracy to commit.
What did he plead to, though? I thought y'all drop a whole lot of gang counts, it seems like.
No,
So.
In this indictment, he pled the conspiracy to commit a crime, which was aggravated assault. He pled the criminal street gang activity, possession of a firearm during the commission of a felony, theft by receiving stolen property, purchase, possession, or having control of a controlled substance in Schedule 1 or 2, excuse me.
Okay, I'm just going to say possession of a firearm during the commission of a felony and possession of a firearm by a convicted felon are both felonies. Okay.
Thank you.
I don't know if there's. So we'll have to figure out what the verdict form is going to look like before we can figure out exactly what we're going to say with regard to how they walk through the verdict form. We also need to take another look at the Overt Act charges and make sure that everything is included that needs to get included that hasn't otherwise been defined in these main charges. So do y'all have a copy of that you can look at?
Yes, Your Honor.
Okay.
This is the copy Ms. Percival circulated at the end of the day yesterday?
Yes, I don't think it's changed since then.
There have been some slight changes too.
There are some slight changes.
Do we have the slight changes yet?
No, because they were going through it literally minutes ago. But I can screen share that if that's the easiest way to do it.
I think so.
Okay. Yes.
Mayor Spokane, real quickly, the three conspiracy charges
Yes.
you're talking about on 18, I've checked those against what you have in the RICO. The only thing that's in those that's not in the RICO that I think should be part of the conspiracy
Okay.
charge is conduct of the alleged conspirators. That's where it stops in the RICO. I think it'd be appropriate to add the words before and after the commission of the alleged offense, if that's an integral part of the conspiracy charge. Otherwise, I think everything that was in those three charges, you're correct, is captured earlier in the RICO.
Okay. So what are the offenses, though? You know, like, I think we kind of got hung up on that yesterday.
Well, here, that's, we're talking about the RICO conspiracy. That would be the commission of the offense that you're talking about.
I mean, I could just say any alleged offense.
Yes, before and after the commission of any alleged offense, yes. Instead of the,
Yeah.
that makes sense.
Would that work?
Yes, Your Honor.
Would that work for the defense?
Okay with it? Yeah, that's fine, Your Honor.
Okay.
Thank you.
Thanks. All right, so with regard to the overt acts, what I was planning to say after I define overt act, so it'll say overt act means an outward act made in furtherance of a conspiracy. The overt act may but does not have to be a crime in and of itself. I was going to say some of the overt acts alleged in this indictment, if proven, would be crimes. You can tell which those are because they will list a cite to a criminal code section. Later in these instructions, I will define for you any alleged crimes that are alleged in the overt acts that I have not already defined. Does that work?
Yes.
Okay. All right, have y'all together coalesced on any type of verdict form or?
I think coalesced, no, we have not coalesced on a jury verdict.
All right.
Coalesced isn't us in the state?
We're maybe closer to congealing than coalescing.
Well, if y'all congealed
Yeah,
on a
they have
verdict
it.
form.
We've prepared one. We've circulated it to them. They got it this morning a few minutes ago. We have not had that discussion yet.
Okay.
The best way to proceed may be to throw it up and then on the screen, and then
Okay.
we can discuss the edits we would like to see.
All right.
That works for Mr. Shard.
It does.
Okay, and I don't know. Are y'all ready to do overt acts? The overt acts definitions? Or no? Yes?
We could do that and come back to verdict form, yes.
I mean, we need to do them both.
Okay, any
So-
order the court would like.
It doesn't matter to me.
Over there.
Okay.
Thank you for that command decision, Mr. Sharp.
This Persefield is like, y'all are all over the place this morning.
I'm just following what Ms. Percival wants.
Wait, that's all any of us wants.
She had a Christina Weaver expression at that point.
All right, do you have it up on the screen? Okay. All right, do we need, so firearm is a deadly weapon, that needs to get charged, but that isn't like a separate charge, right? I mean, I do think that for these overt acts, it would be helpful to leave like assault as a heading if one of the crimes is assault.
Or maybe, I think assault's in there, Your Honor, because one of the crimes is aggravated assault, so, and for aggravated assault, you need to define assault.
Okay.
Maybe,
Well, if it's only aggravated assault, then let's have, can you switch it to say aggravated assault? And is it aggravated assault with a deadly weapon that's the overt act?
Yes, Your Honor.
All right. Thanks. So that'll be to prove assault. So I think underneath there, we'll give the definition of assault. A person, or assault means to commit or attempt to commit a violent injury to someone else.
Yes.
All right, does that work the way we have aggravated assault now?
Yes.
And then do we have simple battery, or how is it listed?
There's an aggravated battery, Your Honor.
Okay, so that would be the same kind of thing then. Well, I don't know that we need the definition of simple battery because aggravated battery is kind of its own definition. You have to actually cause bodily harm. So do we have any simple batteries in the overt acts?
No, Your Honor.
Okay. We have terroristic threats.
Yes.
Was it from the person or from the immediate presence? Or do you want both?
that was, Reggie Hill was a car, and I believe a purse that was in the car. So that would probably be immediate presence.
Okay.
That's correct, Your Honor, in terms of that Overt Act 61 says from the immediate presence.
Okay. All right, and then we have a theft by receiving stolen property.
Yes, Your Honor.
And is it all of those things, receives, disposes of, or retains?
I think receives or retains.
Y'all okay if I just say keeps?
Oh, yeah.
Oops. Do we need to define receiving? I don't think so. I mean, don't y'all think everybody knows what the word receives means?
I think so.
Okay.
Should we say alleged perpetrator?
Instead of, yeah. Well, are we saying alleged perpetrator?
I thought we were saying alleged perpetrator. Are we not?
It's perpetrator.
Just perpetrator? Okay.
Oops. Can you do a global replace of defendant for perpetrator? And we can get rid of that if there's any reasonable doubt, because that's not relevant for here. All right, possession of a machine gun look okay?
Just, Your Honor, for consistency, excuse me, in theft by receiving, the last paragraph says goods. I think everywhere else it says property. Maybe say property, just to be consistent.
Well, it says goods in
It
the second
says
paragraph
goods.
too.
That is one of the pattern charges that has not gone through a plain language rewrite yet, so it's all over the place. Yeah, but I mean, we can say property was.
You say goods in the first sentence as well of the second paragraph.
Let's say the pattern says.
Oh, that's okay. I'm sorry. The pattern. Your Honor.
We okay with this one? All right, possession of a firearm by a convicted felon. I think I'll just lift we already have that defined in our substantive counts, right?
Correct.
All right, so the question is, some of the other acts, crimes, will have been defined already. But for instance, the fact that we have possession of a firearm by a convicted felon, in the other acts as well. Is there a preference for whether it still gets listed in this appendix and just said that's already been defined, or not listed at all?
The state would request to list and to say as previously defined.
Okay. All right.
That makes sense.
Okay. All right, so this one will just say previously defined.
And this will all get cleaned up so it looks kind of the same.
And there'll be some others we have to add in there, I would think, but. So on the possession with intent to distribute, we've got various different substances, I think. Do we want to list all of those that way, or just say the substance?
Yes, I would just say the substance.
Okay. Well, so we'll get that fixed. All right, criminal gang activity. Well, yeah, a bunch of these are already. All right, so that's it that we've got. What else needs to get included from the overt acts?
I'm going through around what I have.
Okay.
1 minute, I'm on.
All right,
194.
great, thank you.
Judge, there's a couple in here that don't have a header on them.
Okay.
Underneath sale of marijuana.
Okay.
There's two that are the possession by an inmate.
Oh, okay, I did not,
Sorry, they
yes,
don't have
okay,
headers on them.
okay, I see them now. I'll just kind of bold them for now. Are y'all okay with, everybody okay with how those two get defined?
Yes.
Yes, Your Honor. And Your Honor, I had one
Yes.
thought with the consolidating the controlled substances.
Uh-huh.
Could we have one sentence that says, for any of these substances, MDMA, methamphetamine, are controlled
Substances,
substances?
sure.
Yes, Your Honor. Thank you.
Can you do that, Laura? Is the defense okay with those two ways that possession of a weapon, possession of a telecommunications device by an inmate are defined?
Give me just one moment, please.
Yeah.
And Your Honor, my list was not exhaustive. Any of the controlled substances like oxycodone that we have, we could just have one sentence with all of those substances, are controlled substances, because each individual one lets the juror know.
Yeah, that's fine.
Okay. Thank you, Your Honor.
I would,
The jail part?
Yes.
Yeah.
I think my personal opinion is it should follow the text of the statute a little bit more and be less specific about while incarcerated in inmate in Fulton County
Yeah.
Jail.
That's a little, totally in Fulton County. Yeah, that one's a little bit. What does it say? At a jail or at a correctional? What does it say? I mean, at a jail? There are all these different definitions. I don't know. Let me pull up if anybody knows. Can give me this.
42,518.
Okay. Can you read what it says? I don't have Lexus up yet. Well, it really says while an inmate.
So I guess it's just for while an inmate.
Okay. Wow, an inmate. happy to say out of jail if y'all want, but
No, just while an inmate, I think, is fine,
Okay.
Your Honor.
so question, I would just think possessed and not was found in possession of. Thoughts on that? It's kind of what the statute
Yeah.
says.
No objection.
Whenever, of course, ready.
Yep,
I
we're
think
ready.
I found, so what I believe we are missing, it depends on how we want to do it, is attempted murder,
Okay,
murder, and then conspiracy to commit murder, and conspiracy to possess a telecommunication device by an inmate.
Was that a conspiracy? The last one?
The last one with Mr. Garlington on the phone with Frank Hubert and Quantavious Greer.
Is that charges? What is that over?
Yes, that is count not count, act 179.
so conspiracy to possess a telecommunications device?
Yes.
So we have Your Honor, we have a possession of telecommunications device by inmate and a conspiracy. Because 170 is possession of.
Okay, so conspiracy to possess a telecommunications device by an inmate?
Yes. That's because they
Is
were on
the conspiracy by the inmate who was trying to possess it or alleged to be by someone else, like helping them? You know what I'm asking?
Yes, it was helping. They discussed possibly flying the phones in the jail through a drone.
You know,
179.
okay, so that would be then, like B1, it's unlawful for any person to procure or give an inmate a telecommunications device, right? So it's a conspiracy to do that, right?
Yes.
So conspiracy to provide right?
Well, conspiracy to.
I mean, the statute is not, the statute's called items prohibited for possession by inmates. And part of what is illegal within there is for another person to obtain, procure, or give an inmate any prohibited item. So, how do you want me to say that? Conspiracy to provide a telecommunication device to an inmate?
The problem is they cited a certain section in the Overt Acts.
Well, how did they say it?
They said in the Overt Act, it says, Demekion Garlington and Quantavious Greer did unlawfully commit the felony offense of conspiracy to possess a telecommunications device by an inmate.
And then described it as how?
when, while speaking over a cell phone to an incarcerated Fulton County jail inmate, discussed a plan to fly a drone carrying cell phones beyond the guard lines to a window
Okay.
at the Fulton County Jail, in violation of 42-518.
Both of those individuals were out of jail and they were,
It does, okay, I understand, but that's not really a conspiracy charge. That's a violation of this statute. But I guess because they didn't actually achieve it, then, okay. Conspiracy to possess
or to provide.
well, y'all said possess. Conspiracy to use a telecommunications device. All right, I may just say. Y'all can be coming up with language for whatever the next one's going to be.
I think the only two that it appears will be the attempted murder and the conspiracy to commit murder,
All right, well,
based on what I have.
figure out the language while I'm working on this one.
Okay.
And so am I going to need to define conspiracy? Or can I just say attempts to? So we're not actually like finding anybody guilty of these things in counts or anything. Y'all tell me.
I agree, Your Honor. I don't think we need to define conspiracy. I think you just put.
So could I just say, a person commits the offense of conspiracy to possess a telecommunications device when that person attempts to provide an unauthorized telecommunications device to an inmate?
Yes.
Okay. That okay with the defense?
When that person,
Attempts to provide an unauthorized telecommunications device or cell phone, I can just say cell phone, to an inmate.
this might be putting the word in the definition, but why wouldn't we put conspires to? Because it's not an
Why
attempt.
wouldn't we put?
It's not an attempt, like,
Okay. I don't have the definition of conspiracy in front of me anymore. I'm happy to say it however way y'all want.
I'm not saying we need to define conspiracy again, but instead of saying when a person attempts to provide why wouldn't we just say when a person conspires to?
Well, I guess just because I was taught you never define a word with the word. But
I understand, but to me,
we can, I'm fine with that.
We're describing a crime.
Fine, conspires.
It's just because attempt is another
Fine with me.
legal term.
There.
Can we?
Okay, that's fine.
I have the conspiracy charge. So
Okay.
a person commits conspiracy to commit possession of a telecommunication device by an inmate when that person, together with one or more other persons, we're going back to what Mr. Shar just said, though, conspires to commit.
Okay.
Mr. Shar.
A person commits the offense of conspiracy to possess a telecommunications device when that person conspires with someone else to provide an unauthorized cell phone to an inmate. Good with everybody?
That's good.
Oh, yes, Your Honor.
Okay. All right. All right, so then we need,
That's Bob.
we will have listed, are these getting listed in the order in which they come as overt acts ultimately, I guess?
If we can,
Okay. So somewhere we'll already have murder. And then we'll need attempted murder?
It seems to make more sense to put them in alphabetical order just because you don't know if the jury may be going back, jumping
I
around,
don't
but
care. We just
whatever.
need to decide on a way. Yes.
I was going to say for the next attempted murder just to cite the pattern instruction 20110, but I think whether it's chronological from the overt acts or alphabetical, either one is,
Attempted murder ought to come after murder.
yes, Your Honor. And because we define murder, the jury will have already been instructed on it for the counts. When attempted murder comes up in the overt acts, I think all that needs to be defined is just attempt, and then murder is previously defined.
Right. Okay. So we'll define attempt.
Which
I
I
like
have
that.
that instruction is simply a person commits criminal attempt to commit insert offense, in this case murder, when with intent to commit, that person performs any act that constitutes a substantial step towards the commission of the crime.
Okay. Where did you get that from? Where could I
Your Honor,
lift that from?
the pattern instruction is 2.01.10, attempt statutory definition from the pattern instruction.
01, perfect. Okay.
And Your Honor, the only other attempt I believe we have is the attempted armed robbery, which is Act 5. But we also we will be defining armed robbery in these overt acts as well.
I'm sorry, but where person, oh, okay, I was looking at the wrong charge. So I think maybe we just do attempt to commit a crime, and then they can reference it for both of them, right?
Yes, Your Honor.
So we're just doing attempt.
Yeah, I think so, yeah.
That's what I have up. You see what I have, Judge?
No, I don't, I was totally doing my own thing. Does that work for y'all, what's on the screen? I think say with intent to commit that crime instead of a crime.
Yes, Your Honor. Stated here.
Yeah, okay.
And should this be criminal attempt or just attempt?
Probably criminal attempt. All right, so conspiracy to commit murder would sort of be like our conspiracy to have the telecommunications device, right? A person commits, where is that? Where do you have?
Okay, this is not quite right, but.
Let me see how murders. I mean, we could just say the crime of murder. To cause the death of another person unlawfully and with malice aforethought, or, I mean, is it just, it could be, can you attempt to commit felony murder? I guess. Beats me.
I don't think if you are, I don't think you can.
No? I mean, we don't, do we want to just say murder, or?
Yes, sir.
Or do we want to say cause the death of another person unlawfully with malice aforethought?
I think just murder, because we would have already defined
All
murder.
right. Certainly. I think that's fine. Everybody all right with that? The way that's defined?
Yes, Your Honor.
Okay. All right, do we think we have all of the, other than the ones we need to just add and say, you know, this is already defined? We think we have everything?
I sent an email, I apologize. As it relates to aggravated battery, the malice definition is different than the malice for murder, and so it's usually given underneath aggravated battery as it relates to what malice means.
Okay. Is that part of the pattern charge?
It's 2.22.31, Your Honor.
Thank you. I can,
I have it, Judge.
okay. I think just drop the whole thing in there and,
I just dropped it in there.
yeah.
It does, I don't know if it all needs to be.
Do you want that first sentence? Does anybody care if we have that first sentence, or just start with malice in this context means?
I think we can start with malice in this context means.
Except it says maliciously, not malice.
Ah, yep. Okay, we'll just leave the whole thing. Anything else on these? Okay. All right, I think we better turn to the verdict form then. All right, so I know Ms. Percifield had taken kind of, I think, I don't know even whose it was, but somebody's from yesterday, and started working on that. And then I know we've got new proposals from the state and from the defense, is that right?
For the verdict form, no, I have complaints, but no proposal, but
I sent some edits in. I have additional edits, but I know I sent one form in with edits.
All right.
But that was prior to the most recent version from the state.
Okay.
And this language is lifted from the charges that we all looked at yesterday.
Should I just start making some comments? Or?
Okay. This is from the court.
It's, yeah, I mean, it's a draft.
On the last sentence that says list each overt act and or pattern of racketeering activity to which you all agree, I believe that we at least need the word, well, I would like the word unanimously before agree, because the pattern has to be unanimous. I'm still looking, that's just one that jumped out.
And then, Your Honor, under this form, would there be yes, no, or how would they?
Honestly, I'm not even looking at it right now. I'm sorry, give me just a minute to.
Yes.
That's a good question.
there's gotta be some way they can agree or disagree with that.
Maybe, on the question of,
Go ahead.
maybe something like on the question on has the state proven beyond a reasonable doubt that the defendant knowingly, and then, so you start out with like on the question or something to that effect, and then the options would be not guilty and guilty.
So, bear with me. The sort of concept that we, I think, settled upon
Last night was that they needed to be unanimous that there was a pattern of racketeering activity,
There would be a pattern.
that a defendant agreed to having somebody commit a pattern of racketeering activity. So maybe, do you agree? Do we want them, I don't know that we want them having to say, I think that as long as they are instructed let me start entirely over. So once we got to the verdict form, I was going to say for count one, the state must prove that the defendant knowingly and willfully agreed to join a conspiracy, understanding that one or more conspirators, himself and or a co-conspirator, would commit at least 2 interrelated acts of racketeering activity within 4 years of each other to either get or keep money or other property or to participate in the enterprise. And the state must prove that any of the conspirators committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. To be unanimous on this count, you must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. You do not have to be unanimous as to specific acts of racketeering activity. You must also be unanimous that at least one overt act was committed after May 10th, 2017 to further a criminal objective of the conspiracy. And then I guess, if you determine that the state has proven all of this, or if you're unanimous as to all of this, you should note on your verdict form any overt acts that you all agree to.
As well as the pattern of racketeering activity that they unanimously agreed to?
I mean,
Was it a question? Or that was a request from me.
Maybe after that first part, which I agreed with and liked and feel that it's an accurate representation of what needs to be proven, that's where we put in the options, you the jury or we the jury find guilty or not guilty or guilty, and then afterwards, if guilty, identify the predicate act. Okay.
Identify the pattern of racketeering activity that you unanimously agreed upon.
And additionally, identify the overact
After that date.
after
May.
that date, act with the S potential, and then
any overt act.
After May
And they don't-
2017.
Well, we could figure out whether they occurred after, I mean, they've been told that if they're gonna list any overt act, then they should list any overt act, not just the overt acts after that date. And then we can figure out whether one of them is after that date.
Every one of them in the indictment has a date attached to it.
Okay.
Your Honor, if I may.
And y'all had asked, either by act number or otherwise, right?
Well, actually, since yesterday.
Yes.
This is going a little bit in reverse order. But the concern that I expressed yesterday was, I think the phrase at that time was, note on your verdict form any overt acts. And in thinking about that, and given that the court's inclination is to tell the jury that if they find overt acts with all the attached requirements, they should list them, is kind of asking them, I don't know what we're going to get if we just say list it. I don't know how they're going to interpret it. So when we sent a verdict form this morning, what we did was attach a list of all of them with a line they can check and to signal that they find it. And just a brief instruction above that says, please check below every act in furtherance of the conspiracy which all 12 of you unanimously agree was committed by one or more conspirator. Honestly, I don't think we have to say both all 12 and unanimously. I think either one is fine. And so we would have, I think we just say unanimously agree. But that way we'll know, they know to begin and they know to end. They know to do the entire exercise. There's 190 as of this point in time, I believe. They go through all of them. They check the ones they find if they find it. That way we don't have them quit early and we don't have them kind of create their own form. I'm very concerned about the opportunity for confusion that presents.
Well, if we're going to use any version of that, it needs to say any act and not every act.
I understand. I get that. You're not instructing them that they have to find an act. I understand that. But this will give us the answer. I mean, if they are going to be told to designate, report those acts they find, then I think a form that takes them through all of them will get the answer. We'll get their answer to each one.
What are the highlights?
Those are acts that may need to come out.
Y'all haven't decided on those yet.
Yes.
Defense?
If they come out, that would only,
Okay.
that would just, we
All
just have fewer. That's
I
all,
understand.
But the principle remains the same.
I prefer the proposal that Your Honor was putting forth. If we use the checklist that the state has put forth, I think it needs to say, please check any the overact with the possibility for plural S, if any, which all 12 of you unanimously agree beyond a reasonable doubt was committed by one or more conspirators.
And I also prefer the court's original suggestion over the checklist.
So, Your Honor, I don't think we need beyond a reasonable doubt again. You've already rejected the idea that we have to put that in everything all the time. They'll be clearly instructed on that. And then
I just really don't like the instruction check below every act, because it just indicates that there is at least one.
I agree.
The state agrees.
We would
If
definitely
the word is
change
any,
that
we have
language.
no objection. So we can take care of that one. And then I have a little more, but wanted to explain that list that we've appended here.
All right,
and
well,
the
I'll
logic behind it.
consider that. Is this in Word form in our folder, Laura?
It's not saved in the folder because it just got sent over this morning.
Okay,
I can save it.
all right. What else, Mr.
The,
Floyd?
Thank you, Your Honor. If we could display the version we had up before, because I don't have a copy of that otherwise.
Well, you can talk about it. I'm looking at it, whether it's
I know.
displayed or
I
not.
just I don't have the words in front of me.
Oh.
In the general premise here, Your Honor, is that I think there's an awful lot in there, and it's.
Oh, I hadn't even looked at what was, honestly, that's just something, yeah, I'm not going to write it like that.
Okay.
It is not, it's going to say count one RICO. Now, I guess it doesn't matter whether they find subsection A or subsection B, as long as they find one of them.
That's correct.
But they all have to agree. But they all have to agree on the same one.
No, they have to agree. They have to agree that.
They have to unanimously agree that it was committed in one of those ways.
But it could be either or both.
But they all have to it couldn't be 6 on one way, 6 on the other.
I don't know. Does anybody know the answer to that? I mean, it's not like in any kind of an aggravated assault case I've ever said, you've got to pick and tell me, did you think that they were, in reasonable apprehension, or did you think some other way?
You're telling them that they have to find they conspired to violate the statute, and they could have conspired in one or both ways, and you're telling them they have to be unanimous. I don't think we have to tell them they have to be unanimous on everything all the time, just like we don't have to tell them that the proof is beyond a reasonable doubt. That is ultimately my concern, because yesterday we spent a lot of time going over your instruction on and as it's expressed here, the 7 elements of each of these two. And they got that, and they're going to take it with them out. So re-expressing this in some way here is never going to exactly match that. If it did exactly match it, it would have no purpose. And if it doesn't exactly match it, it opens the door to some confusion.
Do they have to unanimously agree? Assume they only find one. Do they have to unanimously, all 12, say, yes, it was the conspiracy to violate subsection A? Or?
Number one, no case on it. Number two, if they find both, if they're unanimous as to both, it doesn't matter.
I know. That's why I'm asking if they're not.
I understand.
Okay.
I'm thinking it through with
all right.
You, that's all. If they do not find one, they're not unanimous on one, they would have to be unanimous on the other. If they find both, if they're unanimous on both, it makes no difference. There's nothing more for them to do.
Okay, then I think it has to be listed out as subsection A and subsection B. If everybody agrees, they have to agree, all 12 of them, it's A or it's B.
So it would be, do you find them guilty, not guilty as conspiracy to violate A?
Yeah.
Find them guilty, not guilty as conspiracy to violate B? We don't object to that.
But I disagree with the state in that I do believe that at least having the word unanimous in there would be helpful to the jury, because I really, talking about confusion, I think the racketeering statute is so complex, just to put the word unanimous in isn't that big a deal.
I hear you, but I'm going to tell them, everything you check on this verdict form, you all 12 have to be unanimous about.
And Your Honor, if you're editing the document now, can we view that? Or? Oh, okay. Yeah, we can't view that.
I'm old school writing it down. I don't even know, honestly, which of the documents to use, because I don't love any of them. So.
Just to be clear from the state's view, I think if we had the one we had submitted said, count one, we find the jury not guilty or guilty of conspiracy to violate the Racketeering Influence and Corrupt Organization Act.
We
Based
would
on the
just say
conversation we just had.
Subsection A.
Yeah, and then a second one, subsection B.
Yeah, and they'd both be under count
And,
one.
and I think you would want to say the jury can find them guilty of
Yeah,
one, both, neither.
yeah, agreed.
So that they don't think their job is done if they just check one because
Yeah.
we want that answer.
All right.
But I think with that and the chart on overts, everything that needs to be known is known.
No, because I think since they have to be unanimous on the pattern of racketeering activity, I think that they need to identify the pattern of racketeering
I
activity.
mean,
I can't disagree more.
I understand both of your positions. I think that I will have them, like the one that Ms. Persfield had displayed first, I think, have to say they are unanimous that a pattern,
That would have been.
whatever, however we're going to say it. But I'm not going to have them describe the pattern. I mean, we'll have sufficiently explained it to them. They can just say, yep, we're unanimous.
Okay.
When you asked me over the last couple of days about cases that have used verdict forms that say more than guilty, not guilty, what I've just talked about on behalf of the state, I've never seen one go further than that. Guilty, not guilty, and if there's a question about which predicates or which overts, predicates in a substantive case, overts in a conspiracy case, that's it. I've never seen one that asked any more of a jury than that.
All right. Well, I think I'm just going to sit with all of the proposed verdict forms and put together something that I think makes sense and then show it to y'all later.
Let me lodge a last complaint
'Kay.
before you sit down with them. Also with the states, I don't think I said this, but with the states checklist, I don't know why we would be sending out checklist options for things outside the statute of limitations that can't justify. I mean, we're giving them options to check things that legally cannot support a
Well, if that's
conviction.
all they check and they don't check one that's after May, whatever, then
Okay.
I don't know if I'm going to use the checklist, but if I do, it's going to have everything that goes out. All right, so I will work on a verdict form, thinking about all of the different things we've just talked about. Y'all need to figure out what evidence goes out and what evidence doesn't, because if we're taking, the rest of today and then we're taking tomorrow for y'all to have a work day, once we close and I instruct, I don't want to take 2 hours to figure out the evidence. That needs to go out when they walk out. Y'all understand?
Yes,
Okay. All right, I'm going to step off and we will be in recess, but y'all stay here and work on all of these various things. consulted, what we're going to do is the attorneys are going to stay here and work, but we're going to actually adjourn court for the day. We will not be in court tomorrow. We will be back up at 8:30 on Monday, and y'all are going to get lots of work done in the meantime. All right, thanks.